Okay, I'm going to start up here, and I'm going to mute everyone now so that we don't have any background noise on the recording. But if you want to ask a question, all you do is unmute yourself and at the top of the screen or wherever, and you can ask questions as we go through. We're going to cover paragraph 6 of the contract today, paragraph 7, which is the Virginia Residential Property Disclosure Act. And we will actually take a look at the Disclosure Act that they sent you a copy of also. When we talk about paragraph 7, I get these calls all the time. Buyer moved in, found things that the seller didn't tell them about. Can we sue the seller? And you're going to see the answers. You can sue anybody you want, but the chance of winning is probably 0. Because the law of the land here is caveat emptor, and as long as the proper disclosures were made, nothing you can do really. So we'll take a look at paragraph 7 in detail after we get through paragraph 6, delivery. So if you have your contract package that we sent you a couple weeks ago, dated 7/20/20, I am using the basic contract class from package from that, not the one that we sent you that we use on Ask Larry days. Okay, so this would be on page 3, paragraph 6, delivery. Okay, if you remember in paragraph 31, a contract isn't ratified until it is delivered for purposes of counting days in this sales contract, and delivery is capitalized. So paragraph 6 is the definition of delivery that you find in data ratification. So this paragraph specifies the general delivery requirements under this contract. General. If the word is capitalized, this is what buyer and seller agreed to for delivery. Little d means it's not the definition in paragraph 6 because it was probably defined in statute, and we cannot override statute by the contract agreement. Okay. So it goes on to state, for delivery, little d of the property or condominium owners association documents, see the Virginia POA Act and or Virginia Condominium Act paragraphs of this contract. Several years ago, they basically made the Condo Act and the POA Act the same, just the packets are called different. So I will go to paragraph 8 in a second to show you what the difference is, capital D and little d. All right. Delivery of the notice pursuant to the Virginia Residential Property Disclosure Act is addressed in the Virginia Residential Property Disclosure Act paragraph. So those two laws have different requirements for disclosure. Okay, so we will take a look at both of those as we go to those paragraphs. Goes on to say here in paragraph 6, deliveries will be sent as follows. Addressed to the seller at property address, unless otherwise specified below, by U.S. mail, hand delivery, or courier service, or fax or email. Check all that apply. So you could have a mailing address, fax, and an email in here, or just one of the others. Now the key to this is, if 6A is left blank, where does everything have to go to be delivered to the seller? Well, you will notice the word property is capitalized in this paragraph. And remember, when a word is capitalized, there must be a definition of that term that buyer and seller have agreed to. I don't care what agents agreed to, okay, but what agents think it should be. Contractually, this is what buyer and seller agreed to. So if 6A is left blank, you need to go back to paragraph 1 of your sales contract. Okay, it's called real property, and you will see that it says real property with all improvements, rights, and appurtenances described as follows, and property is capitalized and in quotation marks. So if 6A is left blank, then technically to be delivered, everything would have to go to the property being sold. And if that's a vacant property, I'm sorry, but that's where everybody agreed to be sent. So if it was a capital D in delivery and the agent sent it to that property address and the listing agent says, well, we never got it, I'm sorry, that's what the contract called for. Now I'm going to tell you, most of the time, agents just send stuff back and forth to themselves, irregardless of what the contract says. And that is fine, because you're agents for the buyer and seller. But if I'm an attorney and I'm going into court in a lawsuit, I'm going to say, well, Your Honor, they specifically said it had to go to the property address, and it did not get there. So therefore, it was not delivered. So it doesn't hurt to send another copy also to the listing agent or the buyer's agent. I would do that. But to stay within the terms of the contract, I would see that anything that had a capital D is delivered where it's supposed to go, also in paragraph 6A. You remember we talked about that new form that NVAR put out, information form, that you can fill out all this information to fill out all these blanks properly with the seller. It's an informational only sheet. You download it into the system. The buyer's agents should have all the information they need to fill these blanks out properly. I've always asked our Fairfax Realty agents to call the other side, ask what goes in paragraph 6A and what's the answer to paragraph 14 as a minimum. But if you look at that information sheet that NVAR has, those are the questions that should be answered to properly fill out this contract from the beginning. Addressed to, and then back to paragraph 6, addressed to buyer by U.S. mail, hand delivery, whatever, all that apply. That's usually filled out because buyer agents filling out the contract, they know where their people want stuff delivered. Now, I've often said that I would never put my email address as an agent in here unless I was the buyer or seller. I think that's very dangerous, because if things are delivered to you in accordance with this paragraph, then they have been delivered to the seller. If it had the seller's address, I would take the position that it hadn't been delivered until it actually got to the seller. So I would prefer that you didn't put yourself in that paragraph. I know some agents do because they feel like that's the only way they can control the contract. Just be careful with that. No party to this contract will refuse delivery in order to delay or extend any deadline established in this contract. You see the mail deliverer coming, you're looking out the window, they see you, you see them, don't close the curtain and act like they're not out there, thinking that you'll get more days. Doesn't work that way, okay? Any questions about paragraph 6 and delivery?
Larry, I have a question on
Okay.
6A and B. And this is about when filling out the forms. Paragraph 6A and B says, in parentheses, check all that apply. However, the forms allow only to select one of them. So
you mean when you autofill?
Yes. Since we fill it out this electronically, it's not a hard copy. They don't allow to select more than one.
Okay, I'll make a note of that and send that to the board's attorney.
Yes. And
Yeah,
that's
so that's something they'll have to work on. Won't let
Okay.
you fill out more than one. Okay.
Yeah.
So what happens if you, yeah, otherwise you'd have to autofill and then afterwards check another one. Yeah. Okay. The two that I might see could really put together would be fax or email, because you can send a fax by email now. So I will see that the board's attorney hears about that and see if they can correct that. Okay. Good. Thank you for pointing that out. Okay. And then I think most people usually just check one. And how many people ever check U.S. mail? Well, you know, you're dealing with a bunch of seniors that own real estate. That might be the way they prefer. You know, when my dad was doing anything, it was always, it had to be by, hard copy. He did not have any computer or any of that stuff. And quite frankly, I prefer my stuff hard copy. So I will check into that for you. Okay, any other questions about paragraph 6, delivery? Well, I want you to go to paragraph 8 for a second. Virginia POA Act. Everybody find paragraph 8?
Mm-hmm.
Now, if you go down to B, paragraph 8B, and let me point out, if you haven't seen the changes to the contract this year that went into effect July 1st, paragraph 8 and 9 are 1/3 the size they used to be. They took out all the language that didn't affect every transaction, basically, and moved it into a separate disclosure form that you could give your purchasers, which we will take a look at in our next session, because we'll look at paragraph 8 and 9 in our next session of Contracts 101. But they removed a lot of stuff from this paragraph. So, but I want to pay attention to 8B as in Baker. For delivery of the packet or the notice of non-availability of the packet, the buyer prefers delivery at if electronic or if hard copy. How many of those does the buyer have to fill out? Anybody want to guess?
One.
They have to fill out both blanks.
Both of, okay.
Okay, because our
Larry,
statute. Yes.
Larry, also on B, it's allowed only to enter one of them.
Yeah, and that well, then they really need to fix that. Okay.
Yeah.
Okay. Because our statute says they must deliver in, the seller must deliver the documents in one of the following manners. So that would be, if I'm going to send it to you electronically, what email address do you want? If I'm going to send it to you hard copy, which mailing address do you want? Because our statute says that the seller must deliver the documents in one of the following manners. And if they do, they have met the statute. Okay, so it's actually the seller's decision how it will be done. You will notice that's for delivery. Delivery is lowercase d. So you can go by 6A. Since it's a lowercase d, it's what the law says. And the statute actually spells out the requirement.
So you're saying that both has to be filled out?
Both have to be filled out.
Okay.
It is the seller's choice as to where they will be delivered. I'm going to tell you, most contracts come in with only one filled out, but while they're telling us is that it only allows you to choose one. So I need to check with the board to find out how they can correct that on their autofill, because it's up to the seller how they do that statute wise. If it only comes within one and everybody goes along with it, that's great. But what if it comes in saying electronic only, and I deliver it hard copy to the purchaser in person and get a copy of it? Or I send it by mail return receipt requested, etc. The statute spells out how it's done. We can't override statute with contractual agreement of paragraph 6, right?
Larry?
So, and that's why they separated it out from paragraph 6 and put it in paragraph 8. There were 2 different requirements. Yes.
I would say that if the board changed it, the wording there from or to end, it would help a little bit.
Well, yeah, I've said that to them in the past too, but you know, they're going by what the statute says. So I guess they're trying to stick as close to that as possible. They did change it somewhat because it made it look like in the old contract that there was a choice. And I understand what you're reading there, and I will make that suggestion to them also. I just don't want to suggest too much because then he wants me to serve on the forms committee, and I don't want to do that again. That's a tough job. I just like to criticize the forms, not write them. Any other questions or input?
Larry, just one question.
Yes. Okay.
You said, this is Sylvia. Hi. Larry, what I wanted, can you hear me?
Yes, yes.
Okay, so basically you said that some of the wording from the paragraph 8, Virginia Property Owners Association Act, was moved to an addendum. Is that correct?
No, no. What happened is, oh yeah, oh no, all that information is not an addendum, it's an information sheet.
Okay, does it have to be part of the contract?
No, no.
Okay.
If you are a buyer's agent, please use that form, have your people initial it. They don't have to sign it, but it goes over everything in the property disclosure for not property disclosure, but condo and POA Act. It goes over all that, like when, you know, how many days they have to cancel, but that's basically covered. But you know, the one paragraph I wish they hadn't taken out with that one was that it said up until the time that the buyer received any part of the documents or a notice voiding the notice that they would not be available, the purchaser could void the contract. Okay, and that is what the statute says, but that no longer shows up in paragraph 8 and 9. So I like, you know, at least give them a copy of it, and it goes over all the things that were pulled out. We will actually, I'll have them add that to our class for next week when we look at paragraph 8 and 9.
Okay, thank you.
Okay, good. Any other questions?
Larry, I have a question, but probably it's related on cases where you have a contingency to sell a property. Is there a new form having changed, or that need to be a part of the contingency and clause? Which
one is it? You say for COVID?
No, I am talking about contract with contingency to buyer to sell their property.
Oh, okay.
Is there a new form for that, or is that
no? That's still in the contingencies and clauses addendum forms.
Okay.
Perfect. So that's still part of the contingencies and clauses addendums.
Okay, thank you very much.
Okay, good. Okay, and we will eventually get there. You know, we do about 2 paragraphs a week, but we're going through it line by line in these sessions on Wednesdays. On Mondays, it's Ask Larry, and we can talk about anything you want, but we're literally going to go through this contract so they just know at least my opinion of what the contract says as a strict constructionist, okay? So let's take a look at paragraphs. Any other question?
Yeah, just real quick, Larry. It's Ken Wright, your football. I'm your tight end. You my wide receiver. Okay. Anyways, you said there's another form we have to use with this paragraph 8.
You don't have to use the form, but there is a form that goes over everything that was removed from paragraph 8 and 9 Paragraph 8 and 9 used to be 3 pages in the contract. Now it's 1 page. So they pulled a lot of the stuff out, was just what the law said. So it's just a form that you use with your buyer to go over and have them sign off, and it's, you know, is that they understand exactly what the Property Owners Association and Condo Association Act means.
What's the name of this form, or what's it entitled?
It's I don't have it in front of me, but it's just the condo POA disclosure. I'm
Okay.
sure that's probably the way it's listed in VARs. And we'll actually take a look at it next week as part of paragraph 8 and 9.
Okay,
Okay.
thank you.
Okay. Anybody else have anything about paragraph 6? Okay, let's take a look at paragraph 7. Residential Property Disclosure Act. Okay. Now, like I say, I often get calls. Well, the buyer moved in and now they found this stuff that the seller had to know about and the seller didn't tell us. So the buyer wants to sue the seller. Good luck. This is a caveat emptor state. You know, the seller doesn't have to tell you anything about their property unless you can prove that they intentionally defrauded you, hid it from you. They don't have to tell you anything, okay? They do not have to tell you except for the 5 that we will look at that are mandatory disclosures in Virginia for a seller, okay? Don't confuse this with the duties of a real estate agent. Our statute says that we must disclose any known material adverse fact about the physical structure of the property that we know about. So unless you're actually an agent selling your own home or a property you own, you wouldn't have to disclose. But technically, if you're an agent and you're selling a property you own, you pretty much have to tell everybody everything you know that material affects your property. And that's one of the disadvantages of getting a real estate license in the state of Virginia. So a little bit different requirement if you own the property and you're an agent versus caveat emptor. So don't think you're going to be protected by caveat emptor if you're a licensee. You may not pay damages, but they're going to go after you at depot. All right, so be careful with that.
So you said that we have to declare it, in other words?
If you're an agent,
yeah,
you know of the known material adverse fact.
and you
have
you
to, and you're the listing agent. You would have to tell about the seller's property if you know. If you don't know, you don't have to tell.
If I'm selling my property.
If you're selling your property and you're an agent, okay, the statute says that agents must disclose any known material adverse fact about the physical structure of the property. So if you're an agent and you know, and it's your property, you have to tell.
Right. That's okay. That's okay.
And there's been lawsuits for this in court, and the judges have ruled. That was a known material adverse fact. You are an agent. You should have told. Now, if it was a seller under the same circumstance, they weren't an agent, and it wasn't one of the 5, they probably wouldn't have had to tell. Okay. So let's look at paragraph 7, Virginia Residential Property Disclosure Act requires the seller to deliver a disclosure, little d, right, statement prior to the acceptance. And this is important. Prior to the acceptance, get some background noise. Prior to the acceptance of this contract, unless the transfer is exempt. So it's imperative that you get the owner as a listing agent to fill this out, okay, and download it, put it into the Bright MLS system. But just because it's there doesn't mean it was delivered. When you get a contract registered on your listing, I still use contract checklist to make sure we have everything we need. One thing you definitely need is this has got to be signed by the buyer prior to acceptance of the contract by the seller. Okay? If you don't have it, send it back to the other agent. Tell them, here it is. Please get your buyer to sign this, get it back to us, and we'll present the contract. And you'll see why here in a minute. Okay? Now, unless the parties are exempt, if you go to that Virginia Residential Property Disclosure Act handout that should have been attached to this for today's session, okay? And it's 55-1-700 of our state code. And it talks about on page 1 of this, the exemptions, okay? And we'll take a quick look at them. You should be able to read through them. But transfers pursuant to a court order, including transfers ordered by a court and an administration of an estate. So I'm just finishing up my father's estate as the administrator. When we sold the house, we did not have a disclosure form requirement. Okay?
I'm sorry, Larry. Where
Yes.
are you reading from? Where are you reading from?
You should have been, hopefully
I got
they
it.
sent you.
I got that. I got the form that I downloaded.
Okay, so it's 55.1702 on the first page of it.
Got it. I got it. Okay.
Exemptions.
Mm-hmm.
Okay.
Yep, that's it. Yep.
All right. By court order administrator pursuant to a writ of execution. And what a writ of execution is, the judge has ruled in a case and said, sheriff, go out there, enforce this judgment by taking whatever property they have. And if it's real property, the sheriff can take the property under a writ of execution to pay your debt, okay? Transfers by foreclosure or deed in lieu of foreclosure. A deed in lieu of foreclosure is where you worked out with the lender just to take your property back and not fine you any money, and you signed the deed in lieu of foreclosure, sent it back. Trustee in a bankruptcy, eminent domain. That's where they want to take your property for a road or whatever. Transfers resulting from a judgment for specific performance. If a buyer refuses to settle on a property, one of the things that a buyer can do is go to court and sue for specific performance, make the buyer deliver the property even though they changed their mind. Then that's one of the exemptions. Disclosure Act would be exempt. So also by an assignment of benefit of creditors, you can read those. You probably won't be involved in too many of these exemptions. Where it talks about pursuant to escheats, that's where someone died with no heirs to take over the property, no will, and it would go back to the state of Virginia. You don't need to be able to practice law, but make sure you know when they don't need to fill out this statement. I think probably if everybody would just fill it out, I just ask everybody to sign it, even if it wasn't required, it wouldn't affect them. Okay, so let's talk about number 2 talks about the beneficiary of a deed of trust of foreclosure. That's same stuff. Transfer administration of the state, so they're just relisting them. One, it wasn't there, number 4, transfers from one or more co-owners solely to one or more other co-owners. So if I owned the property with somebody else, I don't want my part anymore, and I sign mine over to them, there's no need for the form. We've all owned it together. And then somebody's going to inherit the property. There's no need for it there under number 5. Number 6, spouses resulting from a decree of divorce. That is, no form necessary. If you don't pay your taxes and the government takes the property. And then transfers involving the first sale of a dwelling. They have a different requirement altogether, but they would still have to, which I find amazing, the one that they think they still need to disclose would be military air installation. which is only down in the Tidewater area. So, okay. So those are the exemptions. When they talk about exemption, you notice that investment property owners aren't exempt. You still have to disclose whatever you knew about the property. As far as the 5 disclosures we're going to look at as mandatory, but you still would have to fill out this form even as an investor selling one of your properties. That's not an exempt category. Okay. All right. Going on here, the law requires the seller on a disclosure statement, back to paragraph 7 on page 3 of your contract. The law requires seller on a disclosure statement provided by the real estate board to state that the seller makes no representations or warranties concerning the physical condition of the property, and to sell the property as is, except as otherwise specified in this contract. If you went back to the contingencies and clauses addendums.
Excuse me, where are you? Where are you?
I'm back in paragraph 7 of your sales contract.
Thank
Okay. And now let's go back to contingencies and clauses. Let me find them in here. So you understand what they're talking about, except as otherwise stated herein. I know it's in here somewhere. If you go back to page 26 in your package for a second, and it should be clauses and contingencies and clauses, you'll see an as-is property condition. You find me page 26, 2B is in Baker. Anyone not find us?
Okay. Yeah, I got it. I got
it. So this is where it says the following terms in this contract are hereby amended. These are what they're talking about when they say except as otherwise contained in this contract, in this paragraph, and also in paragraph 10. All clauses pertaining to delivery of the property free and clear of trash and debris and broom clean are deleted. Buyer assumes responsibility for the smoke detectors, pertaining to termites, compliance with orders and notices of violation of any county or local authority are deleted, and all requirements to comply with POA and condo. Those, even though this contract that we deal with is basically, in the state of Virginia, is basically an as-is contract, these items are still in the contract, and unless they are removed, the seller is still bound by these. The way you remove them from our contract, you check each one you want to remove. They do the crosshair and initial, and then those otherwise contained herein are now removed from the sales contract. Okay. You can remove one, or you can remove all. Yes.
Well, I had an offer. I was a listing agent, and the agent wants me to. It was as is was checked, but he was asking me to go there because it's as is. I have to check all of those. Can she make me to do that?
No, they can't. No, you could just say no, and then you don't have a contract.
I know. So as is, when you're putting it as is, you have to check all of those?
Well, if it's going to be a true as is contract, yes. So if you're buying a property, and I see a lot of times people are writing the terms, this property is coming as is. Well, what does that mean? Because our other contract says, other terms say, except as otherwise contained herein, it's as is. So if I'm a listing agent and my seller definitely wants it sold as is, then we're going to require you, if you want our property, to check all the boxes, initial the crosshair, and remove all the clauses. Otherwise, we don't have an as is contract. Okay. So,
thank you.
So if it's going to be as is, I would recommend as a listing agent, all those be removed also. Okay. Now back to paragraph 7 on page 3 of the contract. If the disclosure statement is delivered, so we're in the second paragraph of it. If the disclosure statement is delivered to the buyer after date of ratification, okay, buyer's sole remedy shall be to terminate this contract at or prior to the earliest of 3 days after delivery of the disclosure statement in person, 5 days after postmark, and you notice delivery is a little d. You don't go by paragraph 6 because the statute is defining what it is, and we have to go by that, right? 5 days after postmark, the disclosure statement is sent by U.S. mail, postage prepaid, and properly addressed to the buyer. Settlement upon purchase of the property, occupancy of the property. This one I don't see anymore, but buyer making written application to a lender for a mortgage loan where such application contains a disclosure that the right of termination shall end upon the application of the mortgage loan, and execution by buyer and seller after receiving the disclosure statement of a written waiver of the buyer's rights of termination separate from this contract. Okay, so if this isn't given to them and they sign it before the contract is ratified by the seller, then all the way up until settlement, they could say, wait a minute, we didn't get the disclosure statement. Can you send it to us? And once they send it to you, they can terminate the contract and say, I don't want the property anymore. Give me my money back. I've known buyer agents who purposely do not include the disclosure statement with the contract signed by their buyer, hoping the listing agent doesn't catch it, and they always have that back in their back pocket for getting their buyer out. I don't agree with that tactic, but I've seen it happen. So be careful. Make sure that it's signed by the parties before the contract is signed by the seller. If it's not, and the seller signs the contract, and then you send a statement over, you still have a contingent contract for 3 or 5 days, depending how it was delivered to the other side. So please be careful with that.
Larry, which statement they have to sign? I'm sorry, I missed this one.
It is the Virginia Residential Property Disclosure Act statement that is a mandated form by DPOR. So it's the one that says you have the right to go to the Virginia Residential Property site, etc. Okay. So written notice of termination may be hand delivered, sent by U.S. mail. You can read through that, how it can be delivered. On to page 4, by seller. In the delivery paragraph, provided the buyer retains sufficient proof of the electronic delivery, which may be an electronic receipt of delivery, confirmation notice was sent by fax or certificate. So if you have some kind of proof that your buyer within the time period sent the cancellation of the contract, voiding of the contract because they had not received a disclosure statement, any such termination shall be without penalty to buyer, and any deposit shall be promptly returned to the buyer. Your seller is going to be upset with you, okay? A lot of other people will be upset with you, but that's what the law is.
Without any reason.
Huh?
Without any reason, right?
Right. Any reason.
Okay.
If they hadn't received this document and they signed and the seller had already signed the contract, you know, after they receive the disclosure statement required by law, they can void their contract for any reason without penalty.
Right.
That's why you want to make sure as a listing agent it was part of the contract that was sent to you.
Okay.
Okay. So let's take a look at some more of this statute. Now I'm going back to the Virginia Residential Property Disclosure Act itself, not in the contract. So we'll see all what was in here in this contract plus some more. So if you look at 55, there's some definitions at the top. I've explained to you what capital letters mean, so in quotation marks. So those are the definitions for the law itself. 55.1701, applicability. The provisions of this chapter apply to, in respect to the transfer, sale, exchange in 1 to 4 dwelling units. 1 to 4 dwelling units. So if I own a single home or a fourplex, I'm bound. If it's a condo and a high rise, it's still by the Condo Act, right? So, but if it's in a 1 to 4 unit building or individual units, then the disclosure is required, whether there's a real estate agent or not. Okay, and that's very important to note here. Whether the transaction was the assistance of a licensed real estate broker or salesperson. You know, if I was dealing with a for sale by owner trying to list their property, I'd question them as to whether or not they had the applicable forms for the Virginia Residential Property Disclosure Act. Make them understand that, hey, there's some things that you might not know about selling, other than that you throw a sign out in the yard, you get a contract. Okay. Now, I want you to go to the second page of this law. It talks about the new builder, new home builder. They don't have to disclose unless there's something that a defect that is known by the builder to exist. No written disclosure is required by this subsection, but if they do have to, so it tells you about when the builder would have to give it to you, and that's if something came up after the certificate of occupancy, etc. You can read through that one for the new homes. I want to go over the required disclosures. 55.1703, required disclosures for buyer to beware. What is the law of the land here in Virginia?
Caveat emptor.
It is caveat emptor. Buyer beware. Broker take care, because they're going to want to sue you, right? But what we're talking about here with buyer beware, you don't have to, the seller doesn't have to tell you things about their property unless it's required. If you've been around a while, you remember we had a law that the seller could disclose everything, or they could just disclaim. No one ever filled out that disclosure form, very few people. So they did away with the actual disclosure form. It had 20 questions they could answer, because number 20 said, is there anything above that we didn't ask that you think is important that you should tell people about your property? And people would turn to me and say, well, what's that other form? Well, it says you don't have to tell them anything. Well, I want that one. Okay. So what they did away with that disclosure form, renamed our statute to be a disclosure, and used a disclaimer form, basically. Okay. But let's take a look here. The owner of the residential real property shall furnish to purchaser a residential property disclosure statement for the buyer to beware of certain matters that affect the buyer's decision to purchase such real property. And the statement now on that new form says that you have informed them that their rights are here and discussed in this act, okay? Such statement shall be provided by the real estate board on its website. Now it goes over what the website shall contain, and you notice the words on each one. Let's look at number 1. The owner makes no representations or warranties. Number 2, the owner makes no representations with respect. Owner makes no representations. So the seller doesn't really have to tell you too much about their property. What the statement is saying, we're caveat emptor. The buyer needs to check all this stuff out, and the seller is not going to tell you about it. And I've had people say, well, how is that disclosure? Well, you know, it's a warning. We're caveat emptor state, seller's not telling you. So the first one, no representations as to the condition of the real property or any improvements thereon with regard to any covenants and restrictions or any conveyances of mineral rights that may be recorded. So covenants and restrictions, you might not be able to do anything you want with this property. You need to check it out, okay? And also they added this one, a residential building energy analysis was added this year, okay? Number 2, any matters that may pertain to parcels adjacent to the subject parcels, including zoning. So what does the statute require? For us, even as agents, any known material adverse fact about the physical structure of the property inside the property line, not outside, okay? And so if you want to, if I'm representing the seller, I'm not telling you there's going to be a county dump on the property next to it. You need to find that out yourself, okay? Number 3, any matters that pertain to whether the provisions of any historic district ordinance affect the property. And this is important because they can't do just anything to their property. It tells you in this paragraph, okay, that in that historic district, they need to review local ordinances creating the district, official map adopted by the locality depicting the historic district, any materials available from the locality that explain requirements to alter, construct, renovate, restore, demolish. So you know that if there's somebody buys a property in the city of Alexandria, that whole area is probably a historic district. So can I just go ahead and change my exterior of my building? No, not necessarily. So they need to understand if it's in that historic district, what does that mean for remodeling and use of my property? Number 4, any resource protection areas established in an ordinance implementing the Chesapeake Bay Preservation Act. Okay. If they buy a property that's within 100 feet of any running water that will end up in the Chesapeake Bay, which is where it all ends up, they're not going to be able to build on the property without an exemption. It may not be able to get the exemption. That even includes putting a deck on a house. If it's going to be within 100 feet of running water, you might not be able to put it on there. So you need, anytime you see running water or what looks like might have been a creek or anything, make sure that people check to see if they're going to be able to do what they want with that property. Number 5, any sexual offenders registered in the chapter, under chapter 387. They need to go to the sex offenders website that hosted by the Virginia State Police, satisfy that requirement themselves. I remember when this first came out, Megan's Law, the proposal was that as real estate agents, we would have to know where all sex offenders live and tell everybody. And I said, I'll get out of the business before I put myself in that position. So the compromise was it had to be on the different forms, including the disclosure form, that they have the right to check that out for themselves. Number 7, wastewater system. Associated with maintenance responsibilities of the wastewater system, which is septic tanks, right? So it's up to the purchaser to do their due diligence to determine the presence of any wastewater system on the property and the costs associated with maintaining, repairing, or inspecting any water system, including any costs for, to pump out the septic tanks, etc. It's up to them to satisfy themselves. We had a client that we always tell our clients, go to FIDO, Fairfax Inspection Database Operations Systems, go to that system, put in the property address, see if any work had been done to the property, and it showed that work had been done to the septic tank and new distribution boxes had been put in 10 years ago. We had them check with the county, and the county said, well, yeah, they did, but they put in plastic boxes, and those are usually good for about 10 years, and then you have a problem. And lo and behold, when we did the septic inspection, all the boxes were cracked, and we had to negotiate with the owner to put all new boxes in, and we negotiated for concrete distribution boxes. So that's what they're talking about. Satisfy yourself. Okay.
What is
Number
the what is
eight.
the site? What is the site for that? You say
It's
there's
FIDO. In Fairfax County, it's FIDO, Fairfax Inspection
okay,
Database.
FIDO.
So if you Google FIDO, every county has it now. Okay. The owner number 8. The owner makes no representation as far as can they put up solar energy collection devices on the property. Number 9, special flood hazard areas. Right. They need to obtain the flood certification themselves. The state of Virginia does not require an owner to tell you if their property is in a flood zone. We had that case. They said, why didn't the owner tell us? Well, the owner doesn't have to tell you. Folks, you can check this stuff out pretty easily. And you should be checking it out before you write a contract. Yes.
Yeah, RPR, Larry?
Yes. If you go to
NAR-RPR to check that out.
Yeah, if you go to NAR-RPR.com, if you're not familiar with it, you should be getting yourself signed up on that. You can do a market analysis anywhere on any property in the United States, but you can check out a lot of other good information. So Google NAR-RPR.com. If you pay dues to an association, you need your NERDS number, your MLS number, and you can set yourself up in a matter of minutes. One of the things you can do is check the floodplain on any property. So if you do a property report, go to heat map, superimpose the heat map over the property for flood zone. It will show you if the property's in a flood area. That one's a matter of 3 minutes. No reason to write a contract in a flood hazard area. Now you can read through these in great detail. I'm just trying to touch on them so you're familiar with what's covered, because I think you really should be discussing this with the buyers before they write a contract. You might even give them the disclosure printed out from DPOR so they can see. Next one, no representation, whether number 10 here, whether it's subject to one or more conservation or other easements. Number 11, the property is subject to a community development authority approved by a local government body. That's where they can have a special tax for systems they put in. Okay. Number 12, this is a brand new one this year. No representation as to whether the property is located on or near deposits of marine clay. They call it Marumsco soils after Marumsco area in Woodbridge. Purchaser advised to exercise whatever due diligence necessary to check out to make sure the soil is okay. If you're not familiar with marine soil, when it gets wet, it can move and houses can actually come off foundations. So they really should check that one out, but the seller doesn't have to tell you their property has marine clay. 13, this one deals with radon, okay? 14, this is another new one. Whether the property contains any pipe or plumbing fixture, solder or flux that does not meet the Federal Safe Drinking Water Act definition of lead-free. This is one that we actually, in our statute now, we have to disclose if we know, okay? They've actually removed Chinese drywall and put this one in its place.
Larry, for
Yes.
marine soil, the owner doesn't have to disclose it?
Nope.
Why?
Because the statute says they don't have to. It's one of the, you got to find out yourself.
Yeah,
okay?
Thank you.
There's only 5 things. You're going to see in a second. There's only 5 things that a seller has to tell a buyer in Virginia. Okay.
Yeah, but if you know something, you said we have to disclose it. That's why it was
the agent. If the agent knows, they have to disclose. Okay. Seller doesn't. But what if the seller tells you, "Oh, the reason I'm moving is the marine clay. We're afraid it's going to shift and cause us some damages." Well, the seller doesn't have to tell, but now who has to tell?
You do, the agent.
You as the agent do, because that's a known material adverse fact. Okay. So
The reason
know.
I'm saying that it was in the Telegraph Road is a part of it. They built a few townhouses, and all of them they have a problem, and they were going after the builder. But what I see right now, I think it was the soil was different.
Yes. Now, but that was new home construction. That's not resale. Okay. And new home construction is exempt from this act. It has its own form and its own rules. Okay?
Larry, can I ask a question for the marine soil, the Marumsco soil? Can we contact the county to find out about that?
Yes, and that's what it's saying. That's what it's saying. If you have any doubt, you need to contact the county and check it out for yourself.
Okay, thanks.
And I tell you who's going to know: the insurance companies, because they probably paid a claim on it.
Yeah.
All right.
Yep.
Okay. Number 15. Remember last year I told you one of the 5 mandatory disclosures, 1-page disclosure form, was this defective drywall. They have removed that from a disclosure to a disclaimer. So number 15 is now makes no representation with respect to the existence of defective drywall on the property, and purchasers are advised to exercise whatever due diligence to find out if it's defective drywall. Okay, that used to be a mandatory disclosure for a seller in the state of Virginia and for an agent, but now they've moved that back into, I'm not telling you you need to check it out yourself. Okay. And then this is another new one, the status of any impounding structures or dam on the property under the ownership of the common interest community. So if your homeowners association has a nice lake, probably the reason they have a nice lake is they probably have a what? A dam holding the water back.
A dam.
Yeah. Okay. So that's a new one. Okay. Now let's talk about the mandatory. Okay. On page 4, there are some mandatory disclosures that if a seller knows, they have to also disclose. Okay. And of course, if we know, we'd have to disclose, but these are the mandatory. 55.1704, disclosures pertaining to a military air installation. Okay. It's really about the specific noise zone and accident potential zone. This is not in Northern Virginia. This one is in Tidewater area, basically. Okay. But 55.1706 was added 2 years ago. Notwithstanding the exemptions, this is pending building or zoning violations. If the owner of a residential dwelling unit has actual knowledge of any pending enforcement actions, they've actually received a notice, okay, pursuant to the Uniform Statewide Building Code that affect the safe, decent, sanitary living conditions of the property, of which the owner has been notified in writing by the locality, or any pending violation of the local zoning ordinance that the violator has not abated or remedied under the zoning ordinance within a time period set out in the written notice of violation from the locality or established by a court of competent jurisdiction. Now, the key here is written notice. Okay. If I finish my basement without a permit, but I have not received a written notice of violation that I didn't have the permits, once that new buyer buys that property, whose problem is it?
New buyer.
The new buyer, because the seller hadn't received a written notice of violation. And that's why our paragraph 20, they took out the word in paragraph 20, requirements. It was a requirement that I had to have a permit, but unless I'd received a written violation, this law said I didn't have to disclose. So we'll look at paragraph 20 someday. But
I see that a lot with decks too.
Okay, so you understand that disclosure. If they have received a written notice of violation and they haven't corrected it, then there is a one-page disclosure form mandated by DPOR, okay, that the seller would have to give the buyer along with the disclosure statement to go to the site. So now there would be two, right? Permissive disclosure of a tourism activity zone. You can voluntarily tell people that you live in a tourism zone. So in the city of Alexandria, several times a year, they're going to close streets down for what? Parades, right? So, and tourism is a big part of the city of Alexandria. So it might, if it's in a tourism activity zone, you could voluntarily tell, but it's not mandatory, okay? 55.1708. We've talked about this one in the past. If you've used your property to manufacture methamphetamines and it hasn't been cleaned up in accordance with the guidelines established by this law, then the seller would have to do a one-page disclosure. So I use that as my icebreaker, so to speak, with owners. You know, have you ever used your property to manufacture meth? If so, we have to disclose on a one-page form. And they think you're crazy, but you know, then I can say, what about the other four? Okay.
Well, Larry, where do we get this? Where do we get this form?
These forms are on DPOR's site.
Okay.
They're probably on NBAR's site also, but they are definitely on DPOR's site.
Okay.
And remember, this is a seller disclosure.
Yes.
And these are whether they've listed or not. Okay. So when these FSBOs are out there doing FSBO and think they know everything, this gives you something to discuss with them. Did you know about this requirement? Did you know about this requirement? And you're bound to do it also. Okay.
Larry, do we have a checklist for the listing and checklist for the sending an offer to buy?
I don't know. There's a checklist.
So we don't miss anything?
There's a checklist of forms that are necessary to turn in to the office. So I think that probably covers it. Also, at the Board of Realtors, they sell a form for $1.25, a folder. And that folder has everything on it that is necessary in a transaction, when you received it, etc. I have copies of it in my office. When I get back in August, if you'd like to stop in, I can share it with you. Okay?
Thank you so much.
Okay.
Larry, I have
Yes.
a question. With these all required disclosures, of course, many of them says that the buyers need to be aware of many of these things, which seems to me that the home inspector now have an extra work to go over more details on inspection. My specific question is, should the inspector cover also items that belong to homeowner association?
I didn't hear that last part about the homeowners association. What about it?
When inspectors, home inspectors, is doing the inspection, do home inspectors need to include also or inspect items related or that belong to homeowner associations responsibilities?
I don't think that the home inspectors have anything to do with that, to tell you the
That's
truth.
it. Yeah.
Okay. Here's my suggestion. If you go to DPOR's site for the disclosure that the form says buy or go here, you know, print that out and share it with them up front. Rather than them have to just go to the site themselves, print it out, okay? And it's broken down into these ones that we looked at that I'm not telling you I have. But there's also a section that they call affirmative disclosures, okay? And the affirmative disclosures are the ones that the seller has to tell if they know they have it. If they don't know they have it, and come to find out it was, they didn't have to disclose it unless they actually knew. So to even go back against someone for these 5 that they have to disclose, you had to prove they knew that they had it, okay? And how many sellers are gonna know about any of this stuff unless we discuss it with them?
0% people.
So that's the
Especially
reason
Facebook.
that's the reason that if you go ahead and print it out, make it part of your presentation, then they know this stuff, okay? So another one that was added that took the place of the Chinese drywall, 55.1708, the required disclosures for stormwater management facilities. So and it says, owner who has actual knowledge of a privately owned stormwater management facility on such property shall disclose. I don't know how they wouldn't know because they're probably paying something. But once again, the law says only if they had actual knowledge, okay? Such disclosure shall be provided, and each one of these says to the purchaser in accordance with this chapter on a form provided by the real estate board on its website. So all these forms are on DPOR's website, but I'm pretty sure they're on NVAR's site also. I know VAR, Virginia Association of Realtors, has it on their website, okay? And if you've never logged on to the state of Virginia Association of Realtor website, there's a lot of good information there from the state attorneys. And all you need to do to log on, you need your NERDS number, your national ID number, and you capitalize your last name. You can register yourself for the site and get to all their good information, okay? Now, 55.1709, time for disclosure, okay? The owner subject to this has to disclose, just like our contract says, prior to what? Ratification of the contract, okay? And on page 5, if the disclosures are not delivered to the purchaser until after ratification, those things are all addressed in our sales contract. We've already taken a look at it, okay? So I want you to go to page 6, duties of real estate licensees, 55.1712. What is our duties under this statute? Well, let's read it. A real estate licensee representing an owner of residential real property as the listing broker has a duty to inform each such owner represented that by that licensee of the owner's rights and obligations under this chapter. So you should be discussing this with the seller. They have the 5 mandatory disclosures. There are the ones that they have the right to check out, but you don't have to disclose. You should be going over that with them. A real estate licensee representing a purchaser, a buyer's agent, okay, then you need to inform the buyer. But look at this. If the purchaser is not represented by a licensee, if there's a customer buying your own listing, then you have the duty to go over the statute with them, okay? The real estate licensee representing an owner of residential real property and dealing with the purchaser has a duty to inform each such purchaser of the purchaser's rights and obligations under this chapter. So if they're a customer, no other agent involved, you still have this duty. And I like this. Provided that a real estate licensee performs these duties, you go over that they have the right to review each one of these, etc. Okay? The licensee shall have no further duties to the parties to a residential real estate transaction under this chapter. It shall not be liable to any party to a residential real estate transaction for a violation of this chapter or any failure to disclose any information regarding any real property subject to this chapter. If you explain the rights and benefits to buyers and sellers under the Act, then you protected yourself. If you don't, you're still holding yourself out for liability, okay? And I want to go over just a little bit more here. I realize we're going a little longer here today. 55.1713. What are the things that an owner has no duty to disclose, period, okay? And that we have no duty to disclose. An act or occurrence that had no effect on the physical structure of the property, its physical environment or improvements located on, or a homicide, felony, or suicide. Okay? Seller doesn't have to disclose, agent doesn't have to disclose. Okay? Those are not material disclosures in the state of Virginia unless it actually affected the property. The example I give, murder in the property, I don't have to tell as an agent. But if the floors were bloodstained and I know they weren't cleaned up in accordance with the health department regs, and the owner just put a piece of carpet over it so people couldn't see it, I know that no material adverse fact, I'm telling. Okay? Not about the murder, I'm telling about the blood in the floors. Okay? And failure for the owner to comply with the provisions, we already looked at that, right? The party has the right to void the contract afterwards. Now, they add and subtract things from this law every year. So 55.1714 says the real estate board, and that's why the board has to maintain the site. The board is responsible for adding and subtracting anything the law says. Okay. Now they changed the law this year to say up until the day the law goes into effect, you use last year's form and last year's law. If you had a listing before July 1st and it's not under contract yet, go out and get the seller to sign the new disclosure form. You need the new one. If you had a listing before July 1st, it went under contract, the old form is still good enough. You don't have to replace it with a new one. And they added that to our law this year to help us out. That's a lot of stuff here in this law. We hit the highlights of it. I would suggest that you read through the whole thing so that you understand. But what our duty is, tell the buyers and sellers their rights under this act, protect yourself, and you should be okay. Any questions about any of that? That's a lot of stuff in one day.
Yes, I have a question, Larry.
Okay.
We have to go over with the seller 51.702, the exemptions, correct?
Yes.
Okay, so if we go over the exemptions with them, pretty much that covers what we need to go with them, right?
Yeah, if you explain the rights and benefits, so if you basically said, look, there's exemptions in this law, here's a copy of it if you want, or if you just download the disclosure form and print it out from D4 on their site, not the form, but on their site. If you just print out the site, it has all these listed, the exemptions, and it has the affirmative disclosures in it. It's a lot shorter than this whole statute. And go over that with the seller, okay? And then do the same with the buyer. Then you protected yourself.
All right,
okay?
Great. Okay.
Yeah.
Larry, excuse me.
Yes.
My name is Sally.
Yeah.
I'm only DC agent. Do you have Zoom on DC classes?
DC classes?
Yeah, I do not do Virginia somehow.
Yeah, no, I just do Virginia. I gave up my DC and Maryland licenses. I only do Virginia and Florida now.
Classes.
But I don't do DC classes, but maybe I think there might be somebody they have that does do some.
Okay.
Okay. Anybody else?
Larry, I have a question about well and septic inspection. So well and septic inspection we have to do separately, right? And which is a better company to do it, and how much do you think? I've done it long back, but I don't have much information. What are we supposed to see in well also, and in septic?
Well and septic has been changed, and the new well and septic form. It allows them to do more inspections than just the coliform disclosure, but it's up to them how much they want to spend and how much they want to do. But I recommend they do all kinds of inspections of the well, lead in the well, and the flow and all that other stuff, because the new well inspection contingency form allows them to negotiate just like a home inspection item.
And this is an older property.
Huh?
So older property. This is an older property. It's like 70s built property. So
yeah, well, I mean, older properties especially, but I don't have that form in front of me, and so I can't really discuss it. But we'll take a look at it in the future.
Okay, sure.
But definitely.
But it's not a deal breaker, right? If well and septic is there, you don't have to get scared of property having well and septic, like the client or something. Because Great Falls and all this are similar, you know, they have only McLean and all, some of these areas are on well and septic.
Yeah.
Like some of the interiors.
Yeah. So,
okay.
But if I was a buyer, I'd use the well and septic inspection and have even the water flow in the well tested for pressure, etc. Because it's just like the, you know, it's just like the home inspection contingency. We can negotiate back and forth or walk or do whatever.
So water flow of the in the well.
They can even do the water pressure flow test. They can do any kind of test they want with that new addendum. It's not just coliform bacteria.
Okay. So we'll use the new addendum. Okay.
Yeah.
Larry, I have a question. For the public water, I have an older house that I am a buyer agent, and my client didn't want to have an inspection. What you're saying that maybe the lead in the water or maybe in the pipe. So that's part of the home inspection, right?
Well, not necessarily, because a home inspector might not be qualified, but they might, you know, if it's a newer home, there shouldn't be any lead involved in it. That would have been old days. The house I had in Arlington, my old house in Arlington, you know, it's had lead bringing the water into the house. So it's not going to be that many properties, probably the older ones. Okay, great. Monday we will be meeting again. That will be an Ask Larry session. Don't know what else we'll be covering on that day, but if you have things you want to discuss, get them to me in advance so I can be prepared for them. But otherwise, I thank everybody that joined. I think we had over 40 people again today, so this is great. Next week in the contract class, we'll be picking up a paragraph 8 and 9, which will be the actual POA Act, and we'll make the POA Act available for you so we can go through it like we did the Disclosure Act. Okay?
Larry, I'm sorry. I'm trying to get on. Larry, I'm trying to get on the VAR website. Do you know the website where we can download, you say, the disclosures for the BPOR?
Well, if you go to DPOR, they have them, Department of Professional Occupational Regulation. But if you Google Virginia Real Estate Association, that's the state association. Log on that site and then put in your NERDS number and your last name capitalized when it asks you to register. Then you should be able to get to their forms, and in those forms they have the disclosures also, because these are drafted by DPOR, not individual boards. But NVAR probably has them. I would think NVAR probably has them also.
Okay.
Okay.
All right. Thanks.
Thank you, Larry. Thank you.
Thank you guys for joining.
Appreciate
it. All right. Have a good day. All right.
Thanks, Larry.
Thank you, Larry.
Thank you guys for joining me. Appreciate it. Bye.
Bye.
Larry, bye. Bye.